Well, good morning, everyone. It's great to see everyone here this morning. Welcome to today's joint hearing of the Senate Business Professions and Economic Development Committee and the Assembly Business and Professions Committee. We will also be joined by the Assembly Arts, Entertainment, Sports, Tourism, and Internet Media Committee at 3 o'clock for a special order. As a function of the legislature's oversight responsibilities today and continuing next Monday, the 23rd, the committees will be conducting oversight hearings to review the several state regulatory boards under the Department of Consumer Affairs and the Business and Professions Code. These hearings are part of the committee's ongoing responsibility to exercise oversight of state agencies under their jurisdiction. The primary purpose of this review is to assess the effectiveness and efficiency of these agencies in protecting consumers and to determine whether changes in the law or in their operations are necessary. Today we will be reviewing specific issues regarding the Cemetery and Funeral Bureau, the Bureau of Security and Investigative Services, the Board of Barbering and Cosmetology, the California Accountancy Board, the Contractor State License Board, the California Architects Board and Landscape Architects Committee, the Board of Professional Engineers, Land Surveyors, and Geologists. To assist members in their review and evaluation of each agency, staff has prepared a background paper which identifies issues and makes staff recommendations for each agency. These papers have been posted on the committee's websites and may be available to all interested parties. Staff has also asked each agency to focus its comments on the more critical issues that have been raised. We will ask each agency to begin their testimony by providing members with a brief overview of their programs and to respond to the more important issues raised by the committee staff. Members will also have an opportunity to raise any other issues or questions they may have. We will also have the opportunity to hear from consumer groups, professional organizations, and members of the public at the end of each particular section. The co-chair of this committee is Assemblymember Susan Bonilla, the chair of the Assembly Business Professions and Consumer Protection Committee, and she is running a little late this morning and will be with us a little later this morning. Is there anyone else on the committee who would like to make a comment or statement this morning? Very good. Thank you, and thank you for being here so early in the morning. Appreciate the promptness of everyone on the committee today. So we'll begin with item 1 on our agenda, which is a review of the Bureau of Security and Investigative Services. So if we could have our two first panelists, Awit Kadane and Laura Alarcon, come forward, please. Good morning. So we'll begin with a brief overview of the Bureau, and then we can go into some of the issues that you'd like to raise or discuss, or following through or on some of the questions that were raised, as well as in the particular issues that are identified in the agenda this morning. Good morning.
Good morning, Mr. Chairman. My name is Awit Kadane. I'm Director of the Department of Consumer Affairs. Good to see everybody this morning. Pleased to be here with both the Chief of my Bureau of Security and Investigative Services, as well as the Bureau of Cemetery Funeral. Both bureaus are very active and have a wide breadth of issues that they cover, a large jurisdiction. Case in point, Ms. Alarcon's jurisdiction covers over 24 licensees and over 300,000 over 24 license types, over 300,000 licensees. Glad to be here, and with that, I'll turn it over to Ms. Alarcon and look forward to any questions that this committee may have.
Thank you.
Thank you.
Good morning.
Mr. Chair and members of the committees. Again, my name is Laura Alarcon, and I have been serving as the Chief of the Bureau of Security Investigative Services for about 20 months now. I would like to begin by thanking you for the opportunity to be here today to talk to you about the Bureau. I would also like to thank committee staff for their time and efforts in identifying the 15 issues in the background paper. The Bureau's highest priority is public safety, and our mission is to protect and serve consumers while ensuring a competent and fair private security marketplace. The Bureau carries out its mission by ensuring applicants meet the requirements for licensure, whether through the application, investigative, or disciplinary process, as well as educating the public to be better formed public security service consumers. That was a tongue twister. The Bureau regulates 7 private security industries governed by 6 practice acts, and the businesses and individuals of these industries include security guards and their employers, private patrol operators, alarm companies and their employees, private investigators, locksmith companies and their employees, repossessors and their employees, and the firearm and baton training facilities that provide that specified training to the Bureau licensees and applicants. There are approximately 336,000 Bureau company employee licenses. The Bureau also issues various permits to these licensees, such as firearm permits, baton permits, and branch certificates. The total number of these permits and certificates is approximately 112,000. Security guards make up the largest portion of the Bureau's licensees, with a population of 280,000, which is about 83% of the Bureau's total licensed population. The Bureau itself consists of 49.9 permanent positions that is supported by 2 funds, the Private Security Services Fund and the Private Investigator Fund. These funds are supported through licensing fees. The Private Security Services Act and the Alarm Company Act authorize the Bureau to use disciplinary review committees, or DRCs. DRCs provide applicants and licensees of these 2 acts an option to the administrative hearing process to appeal the Bureau's decisions of license denials and suspensions, as well as the assessment of fines. The Private Security Services Act provides for 2 DRCs, one for Northern California and one for Southern California. And the Alarm Company Act provides for 1 DRC. Each committee is comprised of 5 members who are appointed by the governor. About 900 appeals are made to the DRCs annually, with an estimated 95% related to security guards and private patrol operators. The Bureau also has a volunteer advisory committee comprised of 13 members who are appointed by my colleague to my right. These committee members provide their insight and perspective on various policies and process issues related to the Bureau. In regard to recent trends, there has been an overall increase in the Bureau's licensed population in the last 3 years. The growth in the number of licensees is generally attributed to the rebounding economy. Emerging technologies are also changing the composition of the private security industry, with a growing number of telecommunication providers adding remote access home security systems to their line of products. Technology is also being employed for training, including the use of firearm simulators and remote access instruction. The Bureau is monitoring these changes and assessing whether regulatory changes will be needed to better protect consumers. The committees have asked what the Bureau hopes to accomplish or improve through the Sunset Review process. Having never been through a Sunset Review, the Bureau is using the process as a means to share information regarding the Bureau and its responsibilities. This process is also helping the Bureau to identify areas where it can improve its operations, and the Bureau looks forward to working collaboratively with the committee staff to make the appropriate changes. I would now like to respond to the issues that the committees have asked me to address today. Please note that I will be responding to the issues in the order that they appear on today's agenda. In response to issues 10 and 11 regarding firearms training curriculum and firearm training instructors and facilities, Bureau firearm instructors are required to instruct the firearms training course in accordance with the Bureau's firearms training manual. While the manual requires discussion on the use and avoidance of deadly force, notably that an armed guard may only use a firearm if there is a clear and present danger to the life of the guard or to the life of another person, there is no practical training requirement related to the application of these concepts. However, the Bureau is open to discuss this issue further with the committee staff. The purpose of the training is to provide the student with an overview of the laws regarding firearms and the use of force through classroom discussions, as well as practice in the proper carrying and use of a firearm. The training in the use of a firearm is designed to develop both proficiency and accuracy by requiring the student to achieve a specified target score for passage of the course. Depending on the skills and knowledge of the student, the training can take anywhere from 14 to 20 hours to complete, with most completing it in between 14 to 15 hours. In regard to enhanced regulatory oversight of firearm instructors, a condition for obtaining a Bureau certification is the possession of a police or security firearms instructor training certificate from the National Rifle Association, or NRA, or a firearms instructor training certificate from a federal, state, or local agency. There is no continuing education requirement for renewing the Bureau instructor certificate, nor is there a requirement for the individual to provide the Bureau proof that he or she continues to possess an NRA or agency certificate. The Bureau is not aware of any issues that have arisen as a result of these not being required, but is willing to explore the benefits of the instructors providing continued proficiency. In response to Issue 9 relating to mental health evaluations, as a condition for receiving a Bureau's firearms permit, the applicant must be cleared by the California Department of Justice Bureau of Firearms to possess a firearm. DOJ notifies the Bureau of an individual's prohibition from a firearm due to various reasons, including specified mental health-related court orders, licensed psychotherapist reports to law enforcement that an individual poses a potential threat, as well as confinement for a period of time for the purpose of a mental health evaluation pursuant to several sections of the Welfare and Institutions Code. There are approximately 45,000 firearm permits, with an estimated 80% issued to security guards. The Bureau is unaware of any investigation that we've conducted to date involving an armed guard firearm incident that included an allegation of the mental instability of the guard. The armed guard firearm incidents that the Bureau has investigated has involved an accidental discharge of the firearm, law enforcement deeming the shooting justified, or the guard exercising poor judgment. Incorporating a mental health screening into the firearm permit application process, whether utilizing a centralized provider similar to how the Bureau administers exams for licensure, or decentralizing one with an independent approved psychologist, would create significant costs to the Bureau and may increase the processing times for firearm permits. In regard to mental health services available to armed guards and individuals involved in guard firearm incidents, these are those generally accessible to crime victims through local law enforcement, which is overseen by the California Victims' Compensation Program. In response to Issues 5 and 8, current law authorizes the Bureau to automatically suspend a guard's registration if he or she is convicted of a crime. While the Bureau is notified from the Department of Justice of the conviction, the Bureau must obtain the court records of the conviction in order to invoke the automatic suspension. The law allows the guard to appeal the suspension through the Disciplinary Review Committee, which enables the appeal to be heard in a timely manner. Current law also authorizes the Bureau to automatically revoke a guard's firearm permit upon notification from DOJ that he or she is prohibited from possessing a firearm. The Alarm Company Act permits the Bureau to automatically suspend a license, including a firearm permit, if a licensee, quote, presents an undue hazard to public safety which may result in substantial injury to another, end quote. There is no similar provision for armed guards in the Private Security Services Act. With regard to firearm discharges, current law requires the guard and his or her employing private patrol operator to file an incident report with the Bureau within 7 days of the guard discharging his or her firearm while on duty. The fine amount that may be imposed on a guard for failing to file the report is $250 for the first violation and $500 thereafter. The fine amount for a private patrol operator failing to file the report is $500 for the first violation and $1,500 thereafter. Committee staff recommend in Issue 6 that the Bureau conduct an analysis of the effectiveness of the current citation and fine structures in the Bureau's Practice Acts. As part of this analysis, the Bureau will consider whether these fines are in need of adjustment. Additionally, since local law enforcement are often the first responders to firearm shootings, the Bureau is exploring opportunities for enhancing their ability to receive tips when a law enforcement officer encounters a shooting involving an armed guard. In regard to Issue 14, the Private Investigator Act specifies that no private investigator or PI licensee shall carry or use a firearm unless he or she possesses a valid Bureau firearms permit. The Act does not provide an exemption to this requirement to PI licensees who possess a concealed weapons permit, nor does it prohibit the PI licensee from possessing a concealed weapons permit. It should be noted that a Bureau's firearm permit alone does not authorize the holder to carry a concealed weapon. Based on these statutory requirements, if a PI licensee wishes to carry a concealed weapon in the course of his or her official business, he or she must have a Bureau's firearm permit to satisfy the firearm possession requirements of the Private Investigator Act and a concealed weapons permit to satisfy the provisions of the Penal Code related to carrying a concealed weapon. If the Bureau encountered a PI licensee who was carrying a concealed weapon without a Bureau's firearms permit, enforcement actions would be pursued. In regard to Issue 7, the Bureau opens an investigation on every complaint received involving alleged unlicensed activity. In cases where Bureau staff is able to locate the unlicensed individual, he or she is educated on licensing requirements and provided with a license application. The Bureau has the authority to issue an administrative fine up to $5,000 for unlicensed activities, with the exception of repossessors. If the individual has not filed a license application within a reasonable time, the Bureau follows up with the individual, and the outcome generally involves the issuance of an administrative fine. The Bureau may also reach out to local law enforcement, the Employment Development Department, and the Department of Industrial Relations for cases involving multiple underground economy violations. Unfortunately, unlicensed activity investigations are challenging since the businesses and individuals are difficult to locate, and the complainant often lacks sufficient identifying information about the unlicensed individual or business. The Bureau believes that an effective deterrent to unlicensed activity is an informed consumer. Toward this end, the Bureau is working with its advisory committee to improve and enhance its consumer education outreach. The Bureau's locksmith and alarm brochures for consumers were shared with the members, and revisions discussed were shared with the members of the advisory committee, and the revisions discussed at a recent advisory committee meeting in February. Given that the Consumer Federation of California and the Congress of California Seniors have members on the committee, discussions were also held regarding strategies for utilizing their networking systems to disseminate the brochures. In closing, I would like to thank the committees again for the opportunity to address these issues. The Bureau will be submitting its written responses to these and the other issues that have been identified in the background paper, and I would be happy to answer any questions you may have at this time. Thank you.
Thank you very much for the testimony. Do we have some questions by anyone other than that? Yes, Mr. Jones.
A lot of the concerns are dealing around firearms and firearm incidences. Do you have any statistics that how many incidences a year you've had to deal with?
Yes. So the current enforcement database, CAS, Consumer Affairs System, does not capture that information. When we started recognizing that there was an interest in this, we have started developing manual workarounds, and beginning in this year, we have started tracking all incident reports, and I've had staff track them back to the beginning of the fiscal year. Since July 1, 2014 to March 1st, we've had 54 reports filed, violent incident reports. Keeping in mind, these are not just firearm discharge reports, but the requirement is for both a violent incident and a firearm.
Okay.
Of the 54, 24 involved firearm discharges.
Okay, so that means the weapon was actually fired for
Correct.
to rise to that level of concern?
Correct.
Okay.
Since that time, we've closed 11. Several of those incidents involved an accidental discharge. We are pursuing 2 with citations because the individual inappropriately used, it was an inappropriate discharge of the firearm into the way they were clearing the firearm instead of the appropriate manner of doing so, as well as using it inappropriately. So we do pursue actions for inappropriate. There are a couple right now that are still pending, and those that are still pending have involved law enforcement investigations as well.
Well, I would imagine in any firearm discharge situation, there's law enforcement's going to be investigating, or there are situations where they
correct.
don't?
For the most part, any time a firearm discharge, they may not. If the guard was sitting in the parking lot returning from duty, and we get an incident report that, because they're supposed to, any time there is a discharge of the firearm, we're supposed to receive an incident report.
Okay.
Law enforcement may not necessarily respond to that type of a situation where the firearm was, just shot in an inappropriate manner, but there was no harm to anybody. Those would be something that we would handle. But yes, when you have other individuals involved and the firearm is discharged, law enforcement inevitably is also involved.
Okay. And then one more question, if I may. On the disciplinary review committees, are those licensees, or who sits on those committees?
Thank you for that question. It's comprised of 3 industry members and 2 public members. As a reminder, it's 5 members to the committee.
Okay. And is that process working well?
Very effectively, yes.
Okay.
In fact, if you look at our statistics in the Sunset Report, being able to use the disciplinary review committees allows us to take disciplinary actions in a much more timely manner than the administrative hearing process.
Okay.
And just one other thing to add, that it doesn't preclude any individual who goes to a DRC, if they're not satisfied with the decision, they still retain their ability to go through the administrative hearing process.
Thank you, Senator Wachowski.
One of the questions that the committee asked on the training, I think I understand there's 8 legal and moral classroom hours, and then there's a continuing education on the field, on the discharge. Given the changing environment that we have, is that adequate simply to do 8 hours of legal training at the beginning and then simply renew your permit with some field discharge training? I mean, I'm thinking about the national attention to incidents in Ferguson, where we might have somebody that presents like law enforcement but is only a private security guard, and there may be a desirability of having them go back to the classroom and getting brushed up on how some of us may think the law should be implemented.
Thank you for that question. So currently, under the regulations, the training hours of classroom instruction is 12. The statute does say a minimum of 8 hours of classroom instruction. The regulations, which were promulgated with not only the Bureau, but also with law enforcement and post at the time that the firearm training manual was developed, landed on the 12 hours of in-classroom instruction, and then on the range not to exceed 8 hours. The goal being that the firearm instructor is to ensure that that individual, in completing the range, has satisfied proficiency and is able to demonstrate safe handling of the firearm. In addition, the regulations in the law requires requalifications for individuals as a condition for renewing their firearm permit, and those requalifications must be essentially quarterly, and each quarterly training also requires a 2-hour training course in use and de-escalation of use. In response to your question, the Bureau is looking at the firearm training overall. In February, we met with the advisory committee and discussed about potential changes, the use of firearm simulators and remote access training incorporated into the firearm training. And as part of all that is arising, not only in the environment, but the issues that are coming forth through the Sunset Review process, yes, it is something we're continuing to look into.
Thank you. Assemblymember Dodd.
I'm wondering, do you develop key metrics at all in terms of trying to determine, what's a high number? Right here is my first committee, meeting to listen to this, and 54 incidents out of over 3,000 people that are doing it. We have. Yeah, so I guess I'm sure with police they've got some metrics, which is how many hours worked and how many incidents. I think it would be interesting to develop a metric that gives us an opportunity to evaluate the severity of this. I have no idea if it's a big. It doesn't seem like a big number, but when compared with police, how many discharges would there be?
That's a very good question, and up until now, the way the database that we have for our enforcement system does not make it easy for us to capture that information. We are doing it manually, and this is something that we are working toward programming into Breeze so that we will be able to monitor this information much more closely.
Senator.
Yes, Assemblymember Jones.
Do you use the Breeze system, or do you have your own database?
The Bureau currently is not on Breeze. We are scheduled to launch into Breeze later this year. But right now we have 2 systems that we use. One is manual that we enter into the applicant tracking system. For the security guard population alone, they are able to use an online licensing system.
So do you have some thoughts about Breeze, concerns? Are you looking forward to being on that system, or would you rather avoid being on that system?
Personally, I'm looking forward to a lot of the robustness that's going to be coming forth with the Breeze.
Okay. And then I just want to back up Assemblymember Dodd's question and have the same concern. And if you can answer it later, if you can answer it today, the accidental discharge that your licensees are having, how does that compare to law enforcement? Because, as some of them are dots, we know accidents happen in law enforcement as well. And I'm sure there's an acceptable rate within law enforcement, and do we have that same kind of comparison here?
Stats do not exist today. These are things that we're continuing to look into. On the advisory committee, we do have representation from the California Sheriff's Association as well as the State Threat Assessment Center, and the hopes is similar to what we did recently in bringing the simulator issues to the committee and having the discussion with the industry as well as law enforcement. Those are the type of discussions that we hope to continue on.
Okay. Thank you, members. I have a couple of questions. One, getting back to issue 5 and the discharge of firearms, and looking at the self-reporting issue. I've kind of had familiarity with self-reporting related to utilities in the district that I represent, and they self-reported, at least in California, their violations. Utilities self-report, and that's like me driving down the street and calling the police and telling them I'm going 69 miles an hour when I'm going 69. I don't believe in self-reporting as the solution, and kind of can create a problem. Have there been instances where you've received an incident report from law enforcement but not a self-report?
Yes, and we follow up on that. We also use media articles. We use also information that comes in through complaints, somebody of an employee or coworker. We use and tips from law enforcement of a shooting. Yes. So yes, the statute requires self-reporting, but we also rely on other means to get the information, and we follow up on that.
Okay. Well, one of the recommendations is for you to develop a new reporting protocol for shooting incidents that does not rely on self-reporting. Is that something that you're looking at?
I believe self-reporting is part of what needs to be required, but in looking at, as I kind of discussed in my testimony, seeing how we can partner better with law enforcement, who are often the first responders out there in a shooting, and getting how we can better communicate. Yes, there's other things that we're looking at to try to see what we can do to enhance that.
Okay, that would be great. Thank you for that. The other part is I noticed on issue 8 in licensure suspensions and holds, the recommendation in that and in looking at it, or the challenge is when, the tools that are necessary against licensees in a timely manner, if there is a violation or a reason to go into some investigation that could lead to whatever actions you may take or follow on, those individuals can continue to go about their business without suspension, if I understand it correctly. You don't generally suspend someone or put their license on hold or do something that gets them out of the field for that position during that period of time. Is there something that you're looking at that could provide that option so that we can, if depending on the severity of the violation or the accusation, that we could be comfortable that the communities are protected if someone is carrying a weapon or acting as a security guard or personnel?
So, Senator, thank you for that question. It's a very good question. Currently, under the Private Security Services Act, which regulates armed guards, we have 2 statutory options to pursue taking disciplinary action on that license. The one is what you just described, which is conducting an investigation, building the case, filing an accusation through the administrative hearing process, having the case go through adjudication, and then the decision. If it results with the revocation, we're able to pull the license at that point in time. You're absolutely correct that during that period of time, the individual continued practicing. However, in the Private Security Services Act, we have a provision of auto-suspend. And the auto-suspension can be invoked immediately upon receipt of conviction, of a criminal conviction. And once we invoke that auto-suspension, the individual is prohibited from continuing to work until such time as the appeal process is completed.
And that occurs after some point in time, not when the accusation or the charge is filed.
That is correct. And if you look at
I'm looking at law enforcement, a person who is in law enforcement, a police officer, if there's a shooting, if there's some action, they go on desk duty, they're removed from duty pending the investigation. And that does not occur here.
That is correct. We are looking into different options of being able to act more timely. I can say one thing. With the auto suspension, we have been able to, if we were to go through the process of the administrative hearing, building the investigation and moving forward, the data has supported that it's significantly longer for the Bureau to be able to take action against the licensee. If you look at the data in the Sunset Report, we were averaging in prior fiscal years about 400 hours. That includes the time of moving through with the Attorney General the administrative hearing process. With the ability to use the auto suspend and take immediate action, we've reduced those times down to 190. That's still not immediate, and we still need to look at options that are similar to what's in the Alarm Act. The Alarm Act does allow for the automatic suspension for any time there's a believed to be a threat. In the Private Security Act, there's no similar provision. That provision only exists relative to the conviction and auto suspension. And the Bureau would be very open to discussing with the committees potential of expanding some of the things that are currently in the Alarm Act into what's available in the Private Security Services Act.
Okay. In the Veterans Employment issue number 15, that was not one that you were asked to respond to, but a question that I had related to that is, have there been any unforeseen circumstances based on the program and or issues raised from the program that should be looked at, in your opinion?
No, the Veterans Come First program was implemented by my predecessor, and it's a really great program. It provides us to have dedicated staff for individuals that report themselves as, current or former military personnel. We are able to assist them with questions. We have dedicated phone lines. Dedicated email. We have once the staff becomes aware, then that individual has the phone number for that individual to facilitate the process, and it is working very well.
Okay, that's good to hear. Thank you. And under issue 14, the concealed carry question, what's the basis of that informal opinion that was released by the Bureau on the issue of concealed carry for private investigators' licenses?
Senator, I'm unaware of any informal opinion. So I have checked around on anything historical that predated me, and we were all a little bit befuddled regarding the informal opinion.
Okay. And the other... What, in terms of the issue 9, the mental health screenings issue, what would be the cost and administrative requirements by the Bureau if you were to implement greater mental health screening protocols of armed guard licenses?
We would have to do additional research, and that would be something that we would like to respond to in our issue paper. On a cursory review, we would have to identify, we would have to have determine whether it's going to be a centralized provider similar to what we use with the licensing exam process, and the development for an analysis and just determination usually runs about $100,000 on those. So it is comparing apples and oranges, but it gives you a sense of potentially what an overall landscape assessment of what would be the appropriate screening tool to be used. Implementing it then would be a contract to be able to carry that out. We would also have to increase staff to be able to review and enter this additional data. We would also require doing computer programming changes, because right now none of the computer systems, whether current or if we launch into Breeze, has the capability right now, the way it's being programmed, to have that information captured and be able to be tracked in the system. So we do anticipate the cost to be quite significant.
Okay. It's unfortunate. Obviously, the cost is there. Are there mental health resources available to security guards from the Bureau if there is an officer shooting, and it can assist them in any way?
There's nothing specifically currently available from the Bureau.
Okay. And there's been, I don't want to say considerable, but I'm sorry.
No, there's nothing that statutorily requires us to provide that information, and at this point in time, resources are being used to do the regulatory activities that we're tasked with carrying out. Not to say that this is not an area that we would look into if this is where the legislature wanted to land, but at this point in time, we don't have anything official to pan out, and we rely on what's usually available through local law enforcement through the Crime Victims Program.
Okay. The couldn't help noticing this morning the article in, I don't even know what it's from, investigative reporting regarding California security firms stay in business after licenses are revoked. I'm sure you saw this.
I only had an opportunity to do a very cursory review of the article. I have not gotten an opportunity to look at the specifics.
I think what it's referring to, and I think this is a follow-up to other articles by the same individuals looking at the officer shootings and some of the other issues that I think we've identified that need to be kind of tightened a little bit, or to at least find some ability to put more controls over the use of those weapons and the reporting of the use of them, and making sure that those who are using or have weapons, the ability for them to have certainly the mental health skills necessary to control that. This, I believe, is related to a firm that went out of business or licensee, and then the person's wife or someone else went and secured a license, and they continued the business as usual after they lost the business before, the license before. So I would hope that there was some response, perhaps, if we can get to the allegations made in this article and the most recent ones. That would be good to hear after you get a chance to look at those.
I can respond to the one question that you just mentioned, or the one issue that you just mentioned about being able to issue to a spouse or not. There's nothing in the statute that prohibits the Bureau to issue a license to a family member if that family member has demonstrated that the individual on which the Bureau previously took disciplinary action is not going to be involved in the business at all.
And evidently that person was in the business. And
that in all indications would be that that individual was not actively involved in the current business. So if the Bureau was going to be looking at those type of issues, that would require additional statutory changes for the authority, because currently we do not have the authority. So long as that individual that's applying and all the individuals that have been identified as, if the corporation is the principals that are being involved, the qualified manager that's involved with the company, if all those individuals meet the experience requirement, they've cleared through the through the criminal history background check, that there's nothing that precludes the Bureau to say that those individuals would not be fit for licensure. The fact that there was a prior family member, there's nothing in the statute that says the Bureau is not able to issue that license.
Yeah, I guess in this case it did show that the person was involved. In fact, there's a picture here of his name on the website. So I don't know what controls or how you can monitor that or how it would be monitored, but I think especially in light of the serious nature of the business that you regulate and control, that greater steps maybe should be taken in order to make sure that the public is protected in that.
No, absolutely. Thank you. And it is a concern to the Bureau, and we are looking into it. And I would like to add that one of the things that we are looking forward to freeze is right now we have two independent databases. We have the licensing database and the enforcement database. Having an integrated system where the information on both is available to everybody is going to also be able to facilitate what's going on from an enforcement perspective when individuals are coming in through the licensing perspective. So those are things that from an IT perspective we're looking forward to, and definitely we're looking into internal business processes to be able to tighten that up.
Very good. Thank you very much. I have no further questions. And Sina, thank you very much for appearing, and we look forward to your comments in writing. Thank you.
Thank you again.
And we will next